Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast, the NJ Laws Tube. And in this edition, we are looking at the nuts and bolts of elder law, which is a program that was sponsored by the New Jersey Institute for Continuing Legal Education. It's a program for attorneys on how to handle their wills, elder law, and estate administration practice. And in our first part, we talked about sending out the questionnaires to clients, having them interviewing the clients, seeing what they filled out, going over what they filled out, and let's see, drafting the documents. Now, let's see, we're now going to talk about a little bit about competency of the client, because the standards for competency in New Jersey are not very high. All someone really needs to know is that they have stuff, that they'll die someday, who they want to get it, and you got to be satisfied that there's no undue influence. And let's see, but typically, I remember years ago, I opened up my office, and it was one of those first nice days of spring where, let's see, the sun was out, the robins were out, and a man called me up and said, my dad wants to have a will, and he wants to do a deed and sign the house over to me. So I said great, because I wanted the business. I go to the house, and the son didn't live with dad. The son is waiting outside, and he brings me in, and we go in, and this dad says to, or the son goes to the dad, Dad, this is an attorney, and he's going to explain to you why you should sign the house over to me. And the old man looks up and says, sign the house over to you? I wouldn't do that. Wait, who's here again? Let's see. And they got son yells to the father louder, this is an attorney, and you should sign the house over to me. He's going to explain you why. And I realized that the son never told the father that he was bringing over a lawyer and probably trying to trick the father into doing stuff. So, let's see. We have a form, and part of it was developed by the esteemed attorney Tom Begley. Doctor, someone can't come into our office. I want two things. I want a note from the doctor saying that the person is competent to do whatever document is requested, and two, I want to talk to him ahead of time. So our doctor's certification of patient capacity, the doctor hands right in their name of the patient, date of birth, and that they're competent to either do, or all of them, power of attorney, living will, trust, deed on house, anything they want. But I will not, if someone can't come to see me, and I'm not sure if they're competent, then I won't do the document. Now, even if the person, the family gets this document, I still want to talk to the person ahead of time, because I don't want to waste a trip like I did, going out to this guy's dad's house where the guy never even told his dad ahead of time. So, and I did get a call one time, fellow who I knew, Mom wants to sign the house over to me. But when can she come in? She can't, because she has a breathing problem. She's on an oxygen tank. Okay, no problem. Let's see. Have the doctor sign the certification. I'll talk to her. And so they get the certification, and the son's pushing to get this deed done. And I talk to them. They call me up. They put Mom on the phone, and I go, "Hi, Mrs. B. How you doing?" And she said, "Well, I'd be doing better if I wasn't on the oxygen tank." "Okay, Mrs. B. Tell me what you want to do." She goes, "I want to sign the house over to Johnny." Now, for a lot of attorneys, that would be fine. Great, I made a fee, and but I want to go the step further. "Mrs. B, how many kids you got?" I got 3 sons." "Well, Mrs. B, if you sign the house over to Johnny, that means that's Johnny's house, and the other 2 don't get any part of the house, and Johnny can sell it. Is that what you want, Mrs. B?" "No, I want all my children to be treated equally." "That's what I assume, Mrs. B. Put Johnny back on the phone." Now, I had previously told Johnny I had suggested for this instance putting the house into a trust, but Johnny didn't want to spend the money, but Johnny was just hoping, I guess, for a quick one. So I want to be careful now. I'm next going to touch upon the power of attorney. Now, in my materials and on my website, I have information dealing with power of attorney. And the clients usually ask, well, what's a power of attorney? I've already named my executive. Well, the power of attorney is basically if someone's disabled, let's say, or can't handle their businesses, you're giving someone you trust the ability to pay your bills, make sure the proper transfers are made, and do everything you could do legally. Let's say, um, and I also explained to them the power of attorney can be effective right away or only upon disability. Now, one time a client asked me, well, what's the difference? I goes, well, that's easy. If it's effective right away, they can steal all your assets right away. If it's effective only upon disability, they have to wait for you to become disabled before they take your assets. So it's important that um, the person knows that they are given. We recommend it, but it has to be someone they trust. And um, we also explain to the people, clients don't just use some form you found on the internet, because that doesn't mention the gift-giving powers under New Jersey statute, public law in 1991. And we also advise against using those computer forms because many were not modified for HIPAA, and we've modified our documents so that under the HIPAA law, which bars disclosure of medical records, that in both our power of attorney and our living will advance directive, it has that. Our clients ask, well, what is it? Basically, what is a living will? Let's see. Well, a living will, like I'd say, people have heard of Karen Ann Quinlan, Terry Chavo, and someone's in a coma, they're comatose, and families fighting over what to do, and um, to go to the Supreme Court, it costs tens of thousands of dollars. And this type of advanced planning takes the stress off the family. I recall when Terry Chavo was on the front page of the newspaper, I remember asking, running to someone, I goes, did you do your document? And they said, yes, you did it. And I goes, what did you pick? You wanted feeding tubes to be provided or discontinued? And they said, I don't remember. And for some reason, I says, you know what, maybe I'll go and check. And I wrote the information on the cocktail napkin, I pulled out the file, and I found out, never signed it. I mean, we mailed it out to them, we sent several letters, we made several phone calls, they never signed it. Well, I can't force someone to sign a document, and there's a presumption, obviously, if it's not signed, then that's not what the person really wants it. Now, when we send out the power of attorney, we have a form letter, and again, it says read it. I'd say the power of attorney is an appointment of another person as someone's agent. It creates a principal-agent relationship, so they have a fiduciary relationship. The person becomes the attorney in fact. For most married people, they make it effective right away. I'd say married people usually effective only upon disability. I'd say the will signing. The will signing. I'd say Tom Begley has taught me many things, and some things about delegation. In my office, oftentimes we have the paralegals and the staff witness the wills, because there's only a few things that only I can do that my staff can't do. Only I can give legal advice as the attorney. The staff can't do that, and only I can go to court. Someone comes in, we've already read the documents, and many times I will call the clients ahead of time. I have something called car calls, and I'm driving around, and I will call the client, goes, hey, this is Ken Vercammen. We mailed the documents on whatever day. You're scheduled to sign on this day. Make sure you read everything and bring the documents with you when you sign. By the time they come in, the office asks them simple questions. Did you read the will? Did you mail or send in any revisions? I'd say if there are revisions, we want them to review the revisions that day. And are you ready to sign? If someone says, no, I did not read the document, we will not sign or execute it until they have read it. And with some of the older senior citizens, let's say I will not even do it that day. Let's say, especially where they were brought in by a child. And I said, listen, I'm sorry, but they told me they haven't read it. It's a 5 or 6 page document, and I'm not going to be a part of where they haven't looked at these documents. And sometimes the families try to say 2 minutes later, oh, they read the document, they didn't understand the question. I goes, no, we understood. They understood the question and the answer. We're not going to do it now. I want them to sign it or to read it the day of signing. Remove anyone from the room at signing, children, beneficiaries, and again, I tell the attorneys, don't notarize something if they do not see them sign it. I'd say it is a criminal offense. I've been asked to notarize things where I didn't sign it, and I said, listen, I can't sell you any marijuana, and I also cannot um, execute and sign something where I can notarize it where I did not see it, and I'm not going to start committing any criminal acts today. I'd say, yeah. Um, we have I put in my materials that I post on the internet a checklist that the staff can follow, um, and then afterwards we send out what's called a post will letter. Let's see, and the post will letter is to remind the clients that it's important to that they should let the executor know where the original will is going to be stored. Let's say, and also we recommend that they provide their executor with our business card and have the executor contact us prior to going to the circuit's office or probating the will. Let's say, yeah, we do recommend to the clients to give a copy of the will to their executor. Let's say, and if they execute a living will, give a copy to the doctor. We remind the clients in our letter not to make any changes to the will because then the surrogate will not, if there's marks up on the will, the surrogate will not admit it to probate. Now, clients sometimes are confused by the word surrogate. What's the surrogate? And I say, well, it's kind of a fancy name for the will clerk. If the will is done right, I'd say New Jersey, they just need the original will with the two signatures, the attorney and notary after it, a death certificate, check for $150 or so, and the circuit afterwards mails them out the paper. So New Jersey's a probate easy state as long as they hire a good lawyer and do it right. Our post will letter also reminds the client that we're available for other matters, but that the file is now closed. But if they have questions in the future, they can call us. We've started something called a client questionnaire, and with a client questionnaire, we're asking questions about how the office handled their matter, and if they're happy. I'd say with the way that we handled our business, because we're there to try to help people out and try to make people happy. Let's see, is there ways to improve our services? Are there any brochures they want? We ask them if their email address because we provide an email newsletter. Let's see. Occasionally cases are referred to us because we also do contested estates, estate administration referred by attorneys. So even though we can't pay a referral fee, we send out a thank you for referral letter right away, and I think that's a good practice because if I refer something a case to another attorney, let's say, and they just ignore it, I'm not going to send them cases in the future. Again, it's not just we oftentimes can't do a referral fee, but a thank you is good. Now, I've put in my materials for the lawyers a referral out to another attorney. Sometimes it's cases that are unrelated to what we handle. Could be a workers' compensation case, could be an employment case, and we'll just say we fax out, we provide the attorney's name to the client, a phone number, and then to the other attorney we'll say, listen, this person might be contacting you. Please handle the matter, and please at least discuss something with them. And we then put at the bottom the date and time of the appointment, or whether or not there was no contact. Now, we fax this to the other attorney. We wait a week. Then we fax it to him again if we haven't gotten a response. If it's ignored, then we send him a third fax. And the third fax says, if you're too busy, basically, if you're too busy to respond to our faxes where we were trying to send you business, then you're probably too busy to take new cases, and we'll think of someone else to send cases to. Let's see. And we also do this because sometimes the clients we send out forget the name of the attorney that we sent out. Let's say I don't do immigration. Let's say we've gotten people come to our office for um, you know, contested probate matters, and who referred you? Oh, an attorney I met. What's her name? I don't know. They were in Hackensack. Well, I feel bad in a way because I would have sent a thank you for that attorney. And that attorney in Hackensack might be thinking, "Hey, you know, I'm, the, I'm not even sending a quick thank you letter." No, there are there are occasionally someone that, let's say, we don't want to represent because they're asking for unreasonable things, or they're just not right. Let's see, and if it's a case that's in litigation, it got to be someone that you're going to want to deal with in the future. So, if it's someone who we don't think that we're going to want to deal with in litigation, let's say, we usually have, we might say some very high fee. In our fee letter, it says it's a no rep unless we're paid. Sometimes we just send out a letter to, especially in personal injury cases, no representation, and there's a statute of limitations, and here's the phone number for lawyer referral. Try, maybe you can find someone else that handles that type of case. Let's see. In non-will cases, we send letters to the clients where we recommend a will, and that's a good way to remind clients that you do more than just the first thing. Now, the last topic we're going to talk about in this presentation doesn't deal with doing documents. It's called social media and networking. Let's say by using the internet, and there are many ways where where the attorneys now post their name and information. Let's say there's both Facebook personal pages and Facebook fan pages for the business. So I put for my running stuff. My running stuff goes on my Facebook regular page. For business, it goes on the fan page. Let's say links to YouTube seminars or information to some of the new articles we've written. I'd say LinkedIn is for professionals, so attorneys join that. Google Plus is trying to compete with Facebook. I own a Macintosh, so I record videos such as this one here. And Twitter is the micro blogging. There's free legal sites. Let's see, where attorneys can post articles and sometimes link to their videos, and those include J.D. Supra, Avo, Justeel Lawyer's Diary, Martindale Hubble Connected, Attorneys Pages, Legal Playground, and LawLink. Other non-legal sites that attorneys can post things. Flickr is for photos. MySpace is more for kids, but at least in my criminal practice, I have that. There's a site called Orkut. Yelp has listings for where phone directories, but it's good to have a location there. And it's also a good idea for attorneys to set up blogs. We provide a free legal email newsletter as information on probate, litigation, community events, and I've always told anyone that they want to subscribe to our email newsletter, they simply need to go to our website, njlaws.com. That's njlaws.com, and they can subscribe to the newsletter there, or send us an email at vercammennews@njlaws.com. For other information on, let's say, wills or probate, there's numerous articles on the NJ Laws website or other website, Central Jersey Elder Law, or contact the law office of Kenneth Vercammen in Edison, New Jersey at 732-572-0500. Thank you and good luck.